we're looking now at electronic or e-justice. Yes. That is something that's come upon us all in the sense that technology and technological change has advanced quite rapidly. Your work here in the topic, what's been the major involvement here in terms of e-justice?
Well, today you can talk about justice without dealing with electronic justice. And that goes to the criminal fields, but also, that's the perspective that interests CDCJ, also in the civil and commercial fields. What's electronic evidence? Basically, if you want to make it very simple, an electronic evidence is any kind of evidence that you take out of a computer or a server that needs software. And nowadays, I would say a huge percentage of the evidence that is used comes from IT, comes either from a computer or from a server.
If someone's house is raided, for example, there's a computer, there's a mobile phone.
You need to go there and seize the computer. You need to collect the evidence. The thing is that there is no common framework in the member states, and that is particularly relevant when you need to make cross-border transferences, for instance, of electronic evidence. So what we decided to do, and we have already finished it, and the Committee of Ministers has already approved it, so is guidelines to member states on very practical, pragmatical things like how should you collect electronic evidence? What should be the probative value of electronic evidence? How should you archive it? How can you transmit it? Things that what we are trying to do is not to create a common framework, but at least to have minimum standards in these areas. Because as I've said before, electronic evidence is becoming more and more relevant, and probably in the future that will be the only kind of evidence that you will find in any proceeding in Europe.